So my name is Susan Vallet. I am on the SPJ Freelance Community Board, and I have been a freelancer on and off for actually most of my career, depending on what point in my career. This latest iteration, I've been a freelancer for 11 or 12 years now. I work in the public radio and podcasting realm and have been involved in the battle against AB5 here in California. Then we had the PRO Act. Now we have the U.S. Department of Labor rule, and we're going to talk about all of that today. First thing, I just want to tell you a couple of things about the organization. So we're kind of co-hosting this between the SPJ freelance community and ASJA. So the SPJ freelance community is the largest and most active community within the Society of Professional Journalists, which happens to be the oldest journalism organization in the country. We have more than 500 community members. We are entirely volunteer run, and we have Facebook and Twitter or X page. I curate the Twitter page. It's all freelance related. You'll find if I see calls for pitches, things like that, I throw that on there. Try to be active every day unless I happen to be gone. And our SPJ members have access to our SPJ freelance community on SPJ's website, which has a pitching database, fellowship and grant database, and an on your own freelancing guide. And we also have a weekly newsletter for SPJ freelance community members. So those are paid members within SPJ. We're co-hosting this with ASJA, which I am also a member of, and that's the American Society of Journalists and Authors, which is the largest organization of professional independent writers. And on the website, I like what they say, telling the world stories for publishers and brands since 1948. So it's basically one of, if not the largest US organization dedicated entirely to freelance journalists and writers. And it's also driven by a small army of volunteers. So if you want to volunteer, either organization, we're open to that. Today, we're going to be talking about anti-freelancer legislation and laws so that you are aware of them and aware of maybe what you can do to try to fight them. There are, I would say, a bulk of us who are freelancing want to stay independent, and we like that lifestyle. And so these are a threat to that lifestyle. So we have two guests today, Debbie Abrams Kaplan, who's a freelancer and with ASJA, and Wilson Freeman, who's an attorney at the Pacific Legal Foundation. I'm going to let them each introduce themselves, starting with Debbie.
Hi, I am Debbie Abrams Kaplan. First, I'm a freelance writer in both journalism and in content marketing writing. I live in New Jersey, and I'm also a co-founder of Fight for Freelancers, which is a nonpartisan, grassroots, self-funded group that's fighting anti-freelancer laws and regulations. Also, I am the ASJA Advocacy Chair, and I'm one of 4 freelance writers suing the Department of Labor, who are represented by Wilson Freeman and Pacific Legal Foundation. There is another lawsuit by writers, including Meg Littman, who I think is on this call, and another colleague. Susan, should I just jump into the rest of my intro, or do we want, and then have Wilson, should we just have, or do you want Wilson to? Okay.
Jump in and then we'll head to Wilson.
Perfect. Okay. So I just wanted to share a little history, which I think will be helpful for context. For some of you, this will be old news. For some of you, it will be very new. I'm going to try to condense it down and hopefully not make it too confusing. It's actually very confusing. So AB5, as Susan well knows, was passed in California in 2019 and went into effect in 2020. That was a law that was very anti-independent contractor. A lot of independent contractors lost work. There's a whole story there. Some, anyway. So that went into effect in January 2020, just as the pandemic hit. Here in New Jersey, we were like, oh, that sucks. California, too bad. At least it's not us. And then at the end of 2019, a copycat bill was introduced in the New Jersey legislature during a lame duck session, and that was to codify the ABC test, which is also used in California. So the New Jersey legislature thought they would just slip it in. They were not expecting that a group of writers had talked to their colleagues in California and saw what was happening. and we were able to learn from what was done there and jump on it right away. So a large contingent of freelance writers, along with some other people, online tutors, and a big group of truckers all showed up at the State House. 4 hours of testimony. It was really trial by fire, testifying in front of a labor committee, as most of us had very little understanding of the issue because it was still so new to us. And we were still trying to understand what the ABC test was and try to explain how it was going to impact our careers when we were still trying to figure all that out ourselves. So at this time, several other writers who are also ASJA members started Fight for Freelancers in New Jersey, and very quickly, like I said, trial by fire, learned how to lobby, learned how to, well, we knew how to write op-eds, but started getting op-eds published, started getting publicity and traction online, got a Facebook group going, got a website going, and really started getting a glimpse into how the sausage is made, and ultimately learned that individuals really can make a difference sometimes. So the bill was killed in early 2020. We have a lot of stories about all that, which we don't have time for today. But around this time, the PRO Act was introduced. The Protecting the Right to Organize Act was introduced. And at the same time, the New Jersey bill was reintroduced in the New Jersey Senate, but not the Assembly, because the Assembly at this point realized what was going on and we had their ear. So we started Fight for Freelancers USA along with our colleague Karen Warren, who lives in Georgia. We kept the New Jersey thing going. We were looking at the PRO Act as well. Long story short, with the PRO Act, it passed the House, it got killed, it passed the House again, and it's just been languishing. There's not the votes there for it to go through the Senate. So there was a lot of lobbying and work on the part of our Fight for Freelancer members. We have about 2,700 members now in our freelance, in our Facebook group. So around, then we had the election, the federal election, and I'm not going to get political, or we are not political, but the Trump administration had created a Department of Labor independent contractor rule just before leaving office, and Wilson can talk more about that because it helps set the background. So right before leaving, he dropped that into whatever you drop that into the universe, and we were all excited because it was actually really good for us. And then he left office, and Biden came in and said, nope, not doing that. We want the ABC test in the tax, tax, employment, and what's the third area? Labor. We want the ABC test in all those areas. So the first Department of Labor rule was in a reaction to the AB5, partly in reaction to AB5. And now we have an administration that loved AB5 and wanted to get it in no matter how. They were not able to get it in through the PRO Act. So now there's a new rule. Long story there, but there's a new rule through the Department of Labor, through the Fair Labor Standards Act, that goes into effect March 11th, which brings us to where we are today. Fight for Freelancers and concerned other independent contractors are potentially fighting a two-prong approach. So we're paying attention to what happens in the states, and we can talk later. Susan, remind me to talk later about what's happening in some of the states, including California, Minnesota, Illinois, New Jersey, Massachusetts, New York. There's things happening or have happened in these areas. And we've got the federal legislation. A lot of people are still talking about the PRO Act, like PRO Act is terrible, PRO Act is terrible, don't, but it's not going anywhere right now. So a lot of people don't realize the Department of Labor rule is the pressing issue right now. So with that, I'm going to introduce Wilson, or Wilson, you can unmute yourself. And
yeah, I'm happy to talk about myself. So my name is Wilson Freeman. I'm an attorney with the Pacific Legal Foundation. Pacific Legal Foundation, or PLF, we're a nonprofit law firm. We litigate cases against the government to defend individuals from government overreach and abuse. Actually, before I joined PLF a few years ago, we represented ASJA in the lawsuit and in their challenge to AB5. I wasn't a part of that litigation, but I do know that that's the case. My background is I've been an attorney now for about 10 years. Before Pacific Legal Foundation, I've had a number of jobs, including in the federal government. At one point, actually, I was in the Department of Labor as an attorney for the Department of Labor during the rulemaking process for one of the independent contractor rules that Debbie mentioned a moment ago. So that's my background. I'm here to talk about the lawsuit that we filed on behalf of Debbie, Karen Warren, Kim Caven, and Jen Singer, who are the co-founders of this informal group, Fight for Freelancers. Pacific Legal Foundation, we believe that freelancers and everybody in America, in fact, has a right to earn a living, and they have a right to work in the way that they want, and the government should basically get out of the way. When you're working as a freelancer, you're running your own business, and that's something the government should respect and foster. Unfortunately, there's been a lot of efforts across the country to limit that freedom, make it harder for people to earn a living as freelancers or as independents. AB5 is a part of that story. Now, sort of the background here is, of course, as you probably intuitively know, but you may not understand the details of, there is a web of laws which govern freelancing. If you're in a state, you have to be aware of state wage and hour laws, state labor laws. You have to be aware of tax law, which is a different question. You have to be aware of federal labor laws. Those are just sort of the three big ones. So AB5, of course, is a state labor law. And so if you're in the state of California, it impacts you very directly. And of course, I'm sure you're very aware of that. If you're outside of California, you have your own state labor laws, which Debbie mentioned in New Jersey. They tried to do something similar to AB5. But everybody in the country, whether you are in California or not, whether you're in an exception to AB5 or not, are governed by this federal labor law, the federal minimum wage and overtime law, which is called the Fair Labor Standards Act. So that's the sort of background here. This lawsuit is about a Department of Labor interpretation of the Fair Labor Standards Act. So it's a rule that the Department of Labor has put out, which purports to adopt a new interpretation and understanding of this sort of venerable old law called the Fair Labor Standards Act. And the Fair Labor Standards Act determines who's an employee and who's not an employee for purposes of federal labor law. So that's distinct from state labor law and distinct from federal tax law, for example. So, it is completely beside the point as to whether you receive a 1099. That's not the question we're talking about here. We're going to be talking about whether or not under federal labor law, you would be considered an employee. So the Department of Labor, as Debbie mentioned, adopted a rule. For the first time, the department adopted a kind of comprehensive interpretation of who's an employee and who's not under federal labor law in the very end of the Trump administration in early 2021. So prior to that, the department had only sort of provided informal guidance. They had left it mostly up to courts to kind of determine on a case-by-case basis, based on a sort of loose assemblage of prior cases, who's going to be an employee or not. That made it really hard for people to know under federal labor law whether they were employees or not. So it differed from state to state. It differed from place to place. So it was just a big challenge. And so the Department of Labor came in under the Trump administration, or under Eugene Scalia, who was the Secretary of Labor at that time, and said, we're going to come up with a new rule, which is a sort of uniform standard, which everybody can apply, which will tell them whether or not they are employees under the Fair Labor Standards Act. Now, you need to understand, of course, the Fair Labor Standards Act, it doesn't govern directly freelancers. It governs employers, right? It's employers who have to pay minimum wage. It's employers who have to pay overtime. So this rule really tells employers, for purposes of the Fair Labor Standards Act, here's which of your workers are going to be considered employees by the Department of Labor and under federal law. So you better make sure that those employees are paid minimum wage and are paid overtime. That obviously indirectly affects freelancers, right? Because if you are considered to be an employee for purposes of federal labor law, I mean, that is going to have major impacts on you, and it's going to have major impacts on your potential your clients as a freelancer, right? As to whether they want to hire you or not will depend on whether or not they think they might have to someday face the Department of Labor for not paying you minimum wage or overtime, not tracking your hours, those sorts of things. Anyway, that's all. Let's back up. The Department of Labor puts this rule out in the beginning of 2021. As Debbie mentioned, the new administration comes in. They don't like this rule. So what they did immediately was they issued a new rule which attempted to withdraw the 2021 Trump administration rule. I'll call it the Trump administration rule, but we call it, I think, in our lawsuit, the 2021 rule. The Department of Labor's withdrawal attempt was actually struck down by a court. A court in Texas said that the Department of Labor had failed to adequately justify their attempt to withdraw the 2021 rule. And so that rule was left in place. And that has been the rule. That rule's been in place since 2021. And that's been the rule that has governed who's an independent contractor and who's not for the last 3 years. Finally, the Department of Labor, just in January, issued their new revised rulemaking, withdrawing the 2021 rule and putting a brand new rule into place. And this new rulemaking purports to offer a much more complete explanation as to why the 2021 rule must go. That's what they have to do because the Texas court said their previous explanation was inadequate. So they had to provide a much more detailed explanation. And in addition to that, now, unlike the previous withdrawal rule, they've added a whole bunch of new content to that rule. So they've effectively adopted an entirely new standard, which nobody has ever seen before. It's not the case that the new rule takes us back to the world pre-2021, where it was just an amalgam of court decisions. Instead, the Department of Labor has adopted a new rule, and it contains a lot of content. It's 339 pages. It's a 6-factor balancing test to determine who's an independent contractor and who's an employee. And it basically doesn't provide clear guidance to employers. And this is sort of the crux. So this sort of gets into the crux of the lawsuit that we brought on behalf of the members of Fright for Freelancers, 4 members of Fright for Freelancers I mentioned earlier. The essential crux of our lawsuit is threefold. First, the Department of Labor has failed to adequately explain the need to withdraw the prior rule and to put in a new rule. Again, they purported to provide a new explanation, but the Texas court that was right in 2021 that they didn't provide an adequate explanation, and they've continued to sort of rely on the same arguments. So we don't think that their new justification passes muster. Second, to the extent the new rule adds all this content and adds all this 6-7-factor balancing test, it's vague. It's too vague for any employer to apply. So employers looking at this rule are simply going to be in a position where they don't know. They can never know. The Department of Labor doesn't give them any clear guidance whether or not an independent contractor that they've hired is going to be considered an employee under the Fair Labor Standards Act. And that sort of vagueness is a constitutional and statutory problem that is fatal to the rule. So those are the sort of crux of the arguments that we're making in our lawsuit. We filed it right after the rule came out, about a week after the rule came out in January, and we filed it in Georgia. And the lawsuit was filed, it's called Warren versus Department of Labor. If you go to our website, pacificlegal.org, you can find a case page where you can read the entire complaint, and you can read our press release, which explains all of this in more detail. I often get asked what's going to happen next. What's the next step? Unfortunately, the next step here is we have to wait for the government to respond. I anticipate the government to file a motion to dismiss our claim as the next steps here, but we'll oppose that. Obviously, that motion to dismiss hasn't been filed. I anticipate it before the start of April, so sometime in March, and then we'll have to respond to the motion to dismiss and see what happens after that. Now, as Debbie mentioned, we're not the only ones challenging the Department of Labor's rule. There is a challenge on behalf of truckers, I think, in Louisiana. There's another challenge on behalf of writers that's been brought in Tennessee. And that Texas case I mentioned earlier is in fact still going and is going back to the district court to file a new claim. So there's a lot of legal challenges to what the Biden administration is doing here with this independent contractor rule. And we're just going to have to wait and see as to whether it becomes the final rule. And I'm very happy to answer any questions. I know that this is very complicated because the department's rule is very complicated. It's 339 pages, as I mentioned, and it doesn't provide clear rules about who's an independent contractor and who's not. So, that's not only a major challenge for freelancers, but that's one of the main reasons that we think the rule has to be struck down. So, thanks for your time.
To set that, just to kind of back up a little bit, because I know even for some people, AB5 and ABC test doesn't mean a lot, like unless you live in California or have been involved in Fight for Freelancers. So I just want to set the stage and define a couple of things so that and so that we can clarify between the two. So California's AB5, which was the law that went into effect in 2020, established the ABC test for determining who's an independent contractor in California. And the ABC test is this three-pronged test. And some states have a less regressive version that's you either have to meet A or B or C. But in California, it was you had to meet A and B and C in order to be considered an independent contractor. And the problem for independent journalists or freelance journalists is that we can't meet the B prong. It's basically saying, the B prong is basically saying that you can't work as an independent contractor for a company in the same line of business that you are. So you cannot do a story for a news outlet, but you could like clean that news outlet's offices, right? So you
can
can't
wash
be
the
in
windows.
the same line of work. So about a year later, California passed more than 100 exemptions to AB5, and it removed this random story cap on writers, but it left other journalists, like those of us in radio, in this gray area and had this chilling effect. And we started seeing freelance gig ads that specifically would say, no applicants from California. And you started seeing this more and more. And as other states started considering the ABC test legislation, then you started seeing those states added into no applicants from those states. Like the companies just don't want to touch that. That same ABC test using A and B and C appeared in the PRO Act, which is where you may have heard of it nationally. At the federal level, obviously that hasn't passed. Then comes this rule. I think one question that has come up in groups is like, how is this Department of Labor rule related to the ABC test, or is it just completely different?
Great question. I mean, and in fact, the Department of Labor confronts that question several times during their rulemaking. The B prong, as you termed it, which is, whether or not you're operating in the same line of business as the entity, is a part of the Department of Labor's balancing test. The Department of Labor calls that the integral factor. I mentioned what the Department of Labor is doing here is a 6-factor balancing test. What the Department of Labor says is that we're not doing the ABC test because, as you mentioned earlier, under the ABC test, you have to meet all 3 of these factors. The Department of Labor has taken a different approach, and their approach is to say instead, we have 6 factors, and among them are the ABC factors, as well as a few additional factors. Control, of course, is one of them. Opportunity for profit based on managerial skill. The degree to what I just call the integral, whether or not you're integral to the employee's business or to the company's business that you're working for. A few other factors that the extent of your investment. And then I should note that the very last thing that the Department of Labor says in their rule is, in addition to these 6 factors, anything else that we may think of may also be relevant to this determination. And the Department of Labor says this is a balancing test, and it's a totality of the circumstances test. And any of these facts may be relevant in a given case. But we're not going to tell you how to balance these factors, or how important any given factor is, or how important any given fact is within any given factor. So let's say you're a freelance writer, for example. You write articles for a magazine, so you're obviously integral to that magazine's business because you're doing the same thing that that magazine does, which is you're producing written content. The Department of Labor will say, and they do say in the rule, that that's one factor, and that factor suggests that you're an employee. But there are all these other factors, so we can't say based on that factor alone whether or not you're an employee or an independent contractor. And they've not provided any sort of useful guidance to businesses on this question. And this is a huge contrast. You have to understand, this is a huge contrast with the rule that was put out in 2021, because that rule put the focus on two factors: control and opportunity for profit. So under the 2021 rule, if you had control over the way that you do your business, if you exercised control over your workflow, your workspace, your method of doing business, and you have the opportunity to profit based on how you do your work and based on your managerial skill and based on the other things that you can do, then the rule said you're more likely than not an independent contractor. So it didn't call it a safe harbor, but it created a kind of safe harbor for freelancers who could then say to their clients, I maintain control over the way I do my business. I do it in the hours that I want to do it. I do it in the way that I want to do it. I work for the clients I want to work for. I write in terms of freelance writers, I only write the articles I want to write. And I have an opportunity for profit because I'm going to pick my clients, and I'm going to pick the pieces I do, and I'm going to pick how I do the work. And they would say, well, that sort of person has a kind of safe harbor against being considered an employee under the Fair Labor Standards Act. The new rule removes that safe harbor, and it says anything under the sun which we can think of, even after the fact, can be relevant in determining whether you're an independent contractor. I mean, we see this is the crux of our lawsuit, because we see it as essentially impossible to answer the question that I get all the time, which is, well, am I an independent contractor or not? I mean, what do I have to do in my business to make sure that I am independent, so my clients are protected from potential liability under the Fair Labor Standards Act? And the answer is, I can't tell anybody what it is they have to do, because the Department of Labor isn't telling anybody what they have to do. The Department of Labor is saying it's a totality of the circumstances test. Anything under the sun that we can think of can possibly be relevant. This is a huge problem from, I think, a statutory and a constitutional perspective. It gives the Department of Labor a sort of Damocles that they can bring down on the heads of businesses they don't like. And it chills businesses from engaging independent contractors, because they know that if they fall out of favor with the Department of Labor, or if they have a bad relationship with a bunch of independent contractors, they could end up being liable based on this test, which didn't give them any useful guidance. So the bright side is, unlike AB5, this is not a sort of execution order, right, that's going to overnight put an end to the business of freelance writing in the United States. It is true that there's no exceptions like there is in AB5. You mentioned there are hundreds of exceptions in AB5. Under the Fair Labor Standards Act, there's no exceptions. If you are determined to be an employee under the Fair Labor Standards Act, that's potential liability for your employer. And that applies to every worker in the country. I mean, there are exceptions in terms of who you have to pay overtime and such, but there are no exceptions to minimum wage, and the overtime exemptions don't cover a lot of people who would otherwise want to be classified as freelancers. So, that's a really important fact, because this rule has enormous impact. And happens, and is going to cover a lot of people who may have thought that under AB5 or under their existing state law they were comfortable that they were independent contractors. Now that's kind of thrown into doubt. And so I think it's going to have a big potential chilling effect, even if it doesn't mean the sort of doom to the field as a whole.
So one of the things that came up and has come up online with regards to this, you heard it with AB5, just form an LLC or S corp. That's all you have to do. So what can freelancers do to protect themselves?
I mean, the Department of Labor basically explicitly says in the rule that the formal organization that you adopt, whether you are an S corp or whether you get a 1099 or however it is that you have sort of set up your organization and your financials, that's just one factor. It doesn't trump any of these. It doesn't trump. We don't know how it trump. Maybe it would trump. I mean, we just don't know. The only way to figure that out is going to be to litigate a case. I mean, really, again, there's no clean way to protect your clients from potential liability, at least under the way the Department of Labor has done it. I guess, without this being sort of blanket legal advice, I mean, anybody can, look at the rule and think about the factors and try to get on the right side of as many of them as you can. That's the safest path. But the Department of Labor is very clear that there's no safe harbor. There's no one thing you can do. There's no two things or three things or four things you can do. In any given case, any of these factors could be determined to be decisive. The Department of Labor expressly says that in the rule. So there's no magic bullet, unfortunately. And I can't provide, like I said, I can't provide legal advice to the many freelancers in this chat. I can just say that, unfortunately, the Department of Labor hasn't given us clear guidance. You can look at the rule, you can look at the 6 factors and try to think about how they might apply to your business and what you can do to get on the right side of them. And then hopefully we win our lawsuit and the rule is struck down and we're back to 2021. I mean, that would be the best case scenario.
You touched upon this a little bit already, and Debbie might be able to weigh in on this as well. What does, I mean, you were talking about the government enforcement would be the government decide, like, I'll go after this company or whatever. Are freelancers at risk for the Department of Labor coming after them?
I don't think freelancers are not under the Fair Labor Standards Act. It governs employers, right? So, it's really more about chilling your business. The Fair Labor, at least from this rule, and I can't speak to the PRO Act because I haven't looked at that, or various state laws because I haven't looked at that, but the Fair Labor Standards Act governs employers, and it provides that employers have to pay minimum wage and overtime and track hours and so on and so forth. And if they don't, then they could be liable for huge penalties, both from the Department of Labor and from potential lawsuits from dissatisfied employees or people who the company thought were independent contractors, who then later they decide they're dissatisfied. So they file a lawsuit arguing that they were employees all along and they should have been paid minimum wage or overtime. That sort of thing happens all the time. That's why this rule is so dangerous, because the post hoc potential here is what's going to chill employers from potentially continuing to do what they've been doing. It's going to be I think it's going to be a gradual effect. Like I said, I don't think overnight it's going to mean the execution of the field for freelance writing or for any other freelance field. I think it's going to be a process where the Department of Labor now, under this rule, which gives it so much more power. I mean, the Department of Labor now with this rule, has accumulated all of this power, and trial lawyers now also have accumulated all of this power. They're going to start using that to enforce a much more rigorous and aggressive understanding of who's an independent contractor and who's an employee. And that will, over time, definitely begin to reduce opportunities for freelance writers. And to be clear, and for freelancers generally, to be clear, I believe that was the intent of the rule. The rule is absolutely crystal clear that the people who supported the rule, by and large, were what they say. They say labor unions and employee advocacy groups, which is essentially, those are labor union advocacy groups much of the time, groups like EPI, the Employment Policy Institute. These are labor union groups. I mean, they obviously have an interest in restricting freelance work as much as possible. The groups who opposed the rule were self-identified independent contractors, by and large, like my clients. So, I mean, I think, yes, I think the purpose of this rule is to make it harder on independent contractors for the benefit of, in my view, labor unions, largely speaking.
And
But
Debbie, what sort of things are you seeing within the freelance groups that you're in?
You know, it's interesting. We just saw an example this week, but I've seen it in the last few years as well with indemnity clauses. You know, we've been arguing about indemnity clauses for years where clients want us to indemnify them for any legal issues about our work. Now we're seeing some indemnity clauses where clients are saying, we want you to indemnify us in case a governmental body comes after us for classification issues, which is super scary. I don't know if that's legal. I don't know if Wilson can answer that, probably would have to look at it. But so we're seeing that. And we are also, oh, okay. So sorry, I was trying to remember the other example I had. We just saw recently in the last month, at least one freelancer who has said in one of the online forums that they've had a client for years, and that client said, because of this Department of Labor rule, they want to now hire them on as a part-time worker, which, you know, the Department of Labor would say that's a success. However, the client also doesn't want to pay them benefits or give them a computer to use or give them any other kinds of things that an employer should be doing if you're an employee. So it's really hard to see how it's helpful to be protected by the Department of Labor when you have employees who are not doing anything really to provide you with additional benefits that you would get as an employee. Other than, I guess you could get workers' comp, but if you're working part-time and you have multiple clients, how do you file for workers' comp? How do you do that? How do you figure out unemployment if they lay you off and you have other clients as a freelancer? How do you get that kind of, how do you file for unemployment when you have other income coming in? Like, it just doesn't make sense. I have one employer relationship. It's been a few years, so this is not related at least to the Department of Labor issue, but I'm a part-time employee there. Part-time freelance, it's the most bizarre title ever. Part-time freelance employee. And I have zero benefits. I don't have a computer. I don't go into their office. I still had to send in my COVID card to show I was vaccinated, even though I've never gone in. I still had to read 3 hours worth of paperwork about not harassing anybody on site. And I've gotten zero benefits out of this. It just, I can't contribute to their 401k plan. Like, it just doesn't make sense. So we are seeing that some employers are paying attention. They don't know not all of them know what to do. And so they're just trying to figure out, and they're coming up with some stupid options. Like, we have to indemnify them for any misclassification issues.
So it's really something to watch out for
by the way.
on contracts then. If you're signing new contracts or renewing contracts with companies, to watch out for that. How, like, would the Department of Labor rule like supersede state laws like AB5, or does this turn into a
yeah, and that's a great
battle?
question. You know, the Fair Labor Standards Act operates in parallel with most state wage and hour laws. So the way that it works is the Fair Labor Standards Act sets what they call a floor for wage and hour regulation, and states can go above that floor. So if you live in California and you're not within an AB5 exception, you know, you're going to be governed by AB5 because AB5 is, California wage and hour law, generally speaking, is much more restrictive and demanding than federal wage and hour law, right? I mean, California has a higher minimum wage. they have all sorts of other requirements. So if you're in California and you're not within an AB5 exception, probably no change for you in terms of this rule. You know, then maybe there's some requirements of federal labor law which will change a little bit, but if generally speaking, if you have a customer or a client that's hired you and you're in California and you're covered by AB5, and I can't think of very many freelance writers who would be, then you'll be, then there probably won't be much change. But if you're in an exception to AB5, then this rule will apply and it will affect you because, again, the federal Fair Labor Standards Act provides a floor. So every employer in the country is governed by the federal or by the Fair Labor Standards Act, and they have to worry if they hire a freelancer at any time. They have to be aware of this rule, and a lot of employers, they're not paying attention or they don't read the Federal Register like I do, so they're not going to even be thinking about this, right? I mean, I talked to a business here, worked with a bunch of freelancers. What it was a driving school, very interesting, where they have their drivers are independent contractors. They don't own the cars. They wear a uniform for the driving school that they're at, and they get hired, and they're contractors who, sort of represent themselves as representatives of this driving school. I know for a fact that under the Department of Labor's test, there's a real question, I think, as to whether those quote unquote independent contractors should be classified as employees. But there's just a lot of businesses in this country that will just continue to do things the way that they've been doing them, and hopefully avoid scrutiny from trial lawyers or from the Department of Labor. What this rule really threatens is a chilling effect. It threatens a long-term diminution in the availability of opportunities as employers become aware of the new rule and as enforcement actions are brought to bring people into line. And I think it's going to be a gradual process unless we win our lawsuit, in which case we'll hopefully be able to reverse it. So
speaking of lawsuits, what sorts of actions are happening to try to stop the rule from going into effect?
Well,
and would the rule be stopped until those lawsuits can work their way through the courts?
I haven't seen, and maybe somebody will surprise me, but I haven't seen anybody you would need to bring what's called a motion for preliminary injunction, which is a motion to prevent the rule from going into effect on a short-term basis while the lawsuit is litigated. But most of the cases that have been brought here haven't had that dimension. Winning a motion for preliminary injunction is difficult. You have to show that the rule is going to impose on you a kind of imminent, irreparable harm. And then you can seek your motion for preliminary injunction, try to get the rule set aside. But as I just noted to you a moment ago, I think that the effect of this rule is going to be a gradual chilling and diminution of availability of business. And my clients have already started to see that, but it's gradual. It's going to be an effect that happens over time. That, I think, is going to make it hard for anybody to stop the rule from going into effect. When it's scheduled to go into effect in the middle of March, I want to say March 23rd, March 21st,
March 11th.
March 11th. Thank you. I should know that, but I don't. But in any case, the point is when the rule goes into effect on March 12th, it's not the case that, as under the ABC test, it's obvious that because of the nature of the rule, as I mentioned a moment ago, the rule is a totality of the circumstances test. It's a balancing test. For any given independent contractor relationship on March 10th, it won't be, I think, obvious that that independent contracting relationship is an employee relationship on March 12th. That's going to take some time to get sorted out as this new rule is enforced and applied by the Department of Labor. And so that means that probably the rule will go into effect but it won't have a sort of overnight impact. It's going to be a kind of gradual impact, and it'll be incumbent on us as one of the parties challenging the rule to to get it set aside. And then that will get the rule set aside. It's just unlikely to happen, I think, before the sort of long process of litigation plays out. I mean, I think we have a very good case to set the rule aside. I think it's just going to take some time.
And so, Debbie, can you talk about why you decided to sue over you and others? We've been talking about it, but like, why you and like personally decided to do this?
Sure. Really, it's a chance to, we've been fighting this. The four of us have been co-leading Fight for Freelancers since 2020 and have been fighting these rules and watching. We've been playing whack-a-mole. And so the opportunity to really take a stand up for what we believe in and put ourselves out there, which, to be honest, is scary. But to be able to put ourselves out there and say, we believe enough in this to sue the Department of Labor. We're really fortunate to have Wilson and his team backing us and supporting us. But felt like it's do or die. Like, how do you go on with your career if you say, oh, I don't want this to happen. Really, I'm so worried about it. And then you have the opportunity to sue and you turn it down. You got to stand up for what you believe in. And so that's what we're doing.
And what is the Congressional Review Act, and how does that play into all of this?
Let me say a couple things. First, I want to thank Debbie and my other clients. This is a great case, and we're very, very privileged to be working with women who are so engaged with this issue and so active in pursuing what they think is right. And that's always our belief at PLF, is that our clients are heroes. And I think the clients here are great examples of that, because it's not easy to stand up in a litigation and to assert your right. It's much easier to sort of stand on the sidelines and let somebody else do it. And our clients have decided to do it themselves. So I really appreciate that. Now, did you want me? I can talk about the CRA as well, if you'd like me to do that.
Yeah.
Yeah, the Congressional Review Act is a statute which allows Congress to set aside, certain rules that agencies have passed. And so this rule is potentially going to be subject to a CRA action. My understanding is that there is an effort to set the rule aside with a CRA resolution that would have to be passed by both houses of Congress. It hasn't happened yet, but then it would also have to be signed by the president. So my concern is that even if the CRA was to be passed, which I think it could be passed here, there have been CRAs against some of the Biden-era rules. I think this rule is not particularly well liked, but I think it's unlikely that the president would likely veto it. So I'm not too optimistic on the prospects of CRA setting this rule aside. And I think I'm much more optimistic on the prospects of lawsuit, either our lawsuit or one of the many other lawsuits that have been brought to challenge this rule.
Let me add in.
Go ahead.
Add in something real quickly. And that is, there is something you can all do about this, and that is to contact your representatives, both your House and Senate, your House reps and your senators, your federal House reps and senators, and ask them to sign on to the Congressional Review Act. It's being sponsored by Bill Cassidy of Louisiana in the Senate, and by Kevin Kiley, who's been one of our heroes in this fight. He's a House rep from California. They are both spearheading it. And so if you can send them a note or call them either way and just say, please sign on as a co-sponsor of the Congressional Review Act to overturn the Department of Labor independent contractor rule. It's a mouthful. That would be awesome. And it's an action you can take.
Yeah, to be clear, I think that sort of action is really helpful. I mean, even if ultimately a CRA is vetoed by the president, I think it still sends a powerful message, which is the message that we've been trying to send with this case, with the particular clients that we have, that freelancers don't want this. And the Department of Labor says over and over again, I think disingenuously, that they're trying to protect independent contractors from the dangers of misclassification, from the risks that they will be bamboozled into being treated as an independent contractor when they're entitled to all these great Fair Labor Standards Act benefits, which is nonsense because, as Debbie indicated, the Fair Labor Standards Act doesn't entitle you to very much. It puts a lot of burdens on your employer, but it doesn't entitle you to, for example, receive health care or to receive a computer or to receive anything except minimum wage overtime, and require that the employer track your hours and call you an employee. So, this disingenuous fear about misclassification, I think, undermines the agency of the freelance community and makes them seem, which is how the Department of Labor maybe sees them, as kind of helpless victims of their clients. And that's just completely contrary to everything I've learned in my time working on this issue, which is that independent contractors want to remain independent. And I think we need to send that message over and over again, because at least some people aren't receiving it.
There was somebody who just related to this. They said that they wrote to their senators about Julie Sue's nomination as head of the Labor Department, and was wondering if we should all do this. I don't want to get into a political discussion here. It's just that she's currently in charge of that department. So, but would that be helpful to contact senators about the nomination of whoever's going to oversee the Labor Department?
Personally, I say go for it. This is her second time being nominated for the role. I don't recall if she didn't have enough votes last time, so they didn't vote, or she got turned down. But either case, she was withdrawn, and they kept her in her acting secretary role and then renominated her again. She is able to serve. My understanding is she's able to serve in the acting role indefinitely. Julie Sue came from California. She was I don't recall the exact title, Department of Labor head there. And she was in charge of enforcing, and also some say the architect of AB5. So she really likes AB5, although when you try to pin her down on it, that the House had a hearing and tried to pin her down on some of that, and she just kept skirting the issue. She's not a friend of ours in terms of independent contractor issues, and she came up, she was in charge of this rule and in charge of getting this all. I shouldn't say she's in charge of the rule, but she's in charge of rolling it out, at least.
And she is in charge of the rule. This is her rule.
It started before her. The process started before her.
The process did start under Marty Walsh, but ultimately, she's signing this rule. There may at some point be, I think, a challenge to her authority to promulgate this rule based on that acting status. We haven't brought that challenge. I would agree that Julie Sue, generally speaking, is not a friend of freelancers. I think this rule is evidence of that. But I don't think that, I guess PLF doesn't take a position on that, but I personally wouldn't object.
And somebody asked to repeat the what you can do instructions, that it went by quickly. In the chat, there is a find your senators link and find your congressperson link. And so you can find out who is representing you and contact them about this. And also about Kevin Kiley's legislation, or not legislation,
Congressional Review Act.
Legislation, whatever, related to the Congressional Review Act. And so that is in the chat box. You'll see that it was posted by SPJ leaders. I had one thing that came up, and I've seen it come up online, and it's why hasn't there been a class action lawsuit again? What would be the benefit of a class action versus what is happening now?
Well, I don't think the way that it's an interesting question. The truth is that there's no need for a class action lawsuit, because generally speaking, federal courts, when this is maybe a too technical of an answer, but generally speaking, federal courts, when they're considering whether or not a rule is consistent with the Administrative Procedure Act. Administrative Procedures Act is the act that governs all federal rulemaking, and that's the nature of that's the basis of our challenge. Our challenge is that the rule is not consistent with the Administrative Procedure Act because it's arbitrary. That's essentially what our rule is. And the remedy for a rule that is arbitrary and capricious, which is essentially our argument, is that that rule has to be set aside, which generally means vacated, gotten rid of. So there's no need for a class action lawsuit in these cases, because if you win and the court determines that the rule should be set aside, usually that means the end of the rule and that the agency has to go back and promulgate a new rule. Some people have questioned whether that should be the case, and maybe we should have to do class actions to get class-wide relief, but generally speaking, federal courts have had no problem on the basis of a plaintiff withstanding setting aside a rule that was that's considered to be arbitrary and capricious or otherwise promulgated in violation of the Procedures Act, the APA.
And
so good question, technical answer.
So it wasn't too technical. We could understand it. I wanted to talk to Debbie for a second just about other things that we could do. And we learned this in California with AB5, and Fight for Freelancers came in and really has taken this in other states. Off the top of my head, I could you can write op-eds for your local newspapers. Lawmakers read their local newspapers, at least they used to. I don't know, what other things would you suggest, Debbie?
I mean, I think at this point for the Department of Labor rule, it's important to contact your representatives about the Congressional Review Act. It's important, I think, Julie Sue, I think that's an important message to send to the senators as well. Op-eds are always great, and especially your local paper up to any kind of digital properties as well. We're seeing some success with people sharing information about this on LinkedIn and on social media. We have a Twitter. You're welcome to follow us on Twitter, of course, Freelancers USA. Karen, please text me right now, message me, and I can say it out loud. We have an active Twitter account. Follow that. You can read about that. But yeah, really sharing what's happening in other places like social media, and so that people who there's some people in the last week we've seen who are like, wait, this is happening. How do we not know about this? No one's talking about it. It's like, we've been talking about it for years. The problem is you only have a reach so far. You need to be able to reach other people. Freelancers_USA. That's the Twitter handle. So please follow us. Join us at Fight for Freelancers USA on Facebook. We have calls for action there, and we share all kinds of information, and people ask questions. It's a nice community. And really that's a great place to learn more about what to do. Can I bring up the states for a second before?
Yeah, it was further down on my list.
We can do it later then. That's fine too.
We can do that now too. I want to, there was actually somebody who asked a question related to this that I wanted to,
yeah, sure.
So I was going to leave the questions that you guys are asking in the Q&A until the end, but if I see that they're related, I'm just trying to bring it in while we're talking about stuff. Somebody requested to repeat the what you could do info, which we just did, and could it be posted in the Q&A or sent out via email with recording? Yes, we can figure out something.
Yeah.
Somebody else has asked, could you please repeat the language for what we are supposed to ask of our reps and senators?
Yes. So ask them to support Kevin Kiley in the House or Bill Cassidy in the Senate to support the Congressional Review Act to overturn the Department of Labor's independent contractor rule.
And then
I had to repeat that to my parents about 5 times because I was having them do this as well. And they're like, well, let me get a pen. I'm like, I emailed it to you. They're like, let me get a pen and write it down again. So it's a mouthful. I totally get it.
Yeah, and I think Jenny, who's running our tech stuff, will probably repost. Somebody has posted the language in what only the panelists can see, and Jenny will probably repost that into the chat box. Somebody, just a quick question: do content creators and social media influencers fall under the rule also?
Well, I would think that anybody who's an independent contractor could be subject to the rule.
Yeah, well, like I said, the Fair Labor Standards Act applies to every employer in the country, every business in the country. Yeah, the question would be in the case of the social media, person whether or not they're considered an employee under the Fair Labor Standards Act, and it applies to everybody. So yes, they could be subject to the rule if the business that hires them needs to be aware of the potential consequences of working with them and whether or not they could, end up being liable under the Fair Labor Standards Act. But again, as a social, again, this rule is more going to affect your clients, and it's going to affect your business by chilling, your clients and making them less willing to work for you. If you're a social media intern, don't worry that tomorrow you're going to be considered an employee, because that's really your employer. It's your employer's problem. That it's going to affect you if they come to you and they tell you that you're not a freelancer anymore. That's going to affect you. But the liability that I'm talking about under the FLSA attaches to the employer.
And I think it's important to point out, I don't know if everybody always realizes this. When you lose your independent contractor status, or your status basically as a small business, you lose your ability to write off your, like in my case, radio equipment, your healthcare. You have to pay into we're paying into Social Security anyway, because we pay our taxes. But you don't have the ability to tap into unemployment or disability, because you're maybe disability, but your unemployment, you're never going to lose all of your clients at the same time. So you're never fully unemployed. So you would never be able to take advantage of that. So you lose a lot of the perks you get as a small business owner. So I just wanted to clarify that, in case some people are like, well, it's no big deal.
Can I
just
throw a
move
few more
over to a
things in?
W-2 and it's not a problem. No, you lose all of your write-offs as a business.
You lose your home office deduction, you lose your phone deduction, all of your equipment, like you said. Also, there's an issue for your retirement, because if you're not getting your retirement benefits through your employer, and even if you're working part-time, you're not going to necessarily get that much. If you're self-employed, you can do the 401k, an individual 401k, or a SEP IRA, and you can put away, I want to say 64,000 or so per year in retirement benefits. If you're an employee, it's a lot less than that. And so you're looking at maybe a $6,000, $7,000 IRA, or whatever you can contribute, a percentage of your income you can contribute to a 401k. Maybe your employer would throw in a little. It's not going to match the up to 64,000 a year. Granted, not everybody can contribute that much, but that's a huge loss. And you can deduct, if you can use that as a deduction as well.
Yeah. Jen Singer was wondering if we as freelancers hire other freelancers for research or editing or fact checking or whatever, isn't that an issue under this Department of Labor rule? Like if freelancers, like if you're basically an independent contractor hiring another independent contractor to do something.
Yes. Again, that everybody is covered by this rule. So that's a great example of somebody who needs to be aware of the FLSA regulation. If you're hiring freelancers, then you're in a position of potentially being classified as an employer. And I'm not saying that you can't hire freelancers. I think that you just need to be aware of the rule. You need to be aware of its potential consequences on your business. And if you want to work with freelancers, you need to hopefully, try to get on the right side of the factors. There's no safe harbor. There's no magic bullet. And there's nothing I can say to you that would give you comfort that the freelancer you're working with won't be classified as an employee. But that is a situation where, yes, you could be potentially liable. I don't know your particular circumstances, and even if I did, I wouldn't be able to tell you how it would shake out in a court or in the Department of Labor. But it goes to show you why we think the rule is unlawful, because nobody Nobody knows what's going to happen in those circumstances. One of our clients makes that exact allegation in the complaint, which is that she works with freelance editors and a freelance writer and a freelance, checker, but she doesn't know whether she can continue to do that going forward. And I think that's a real problem.
And so just shifting gears just a little bit here. So the ABC test legislation, which is like what we saw in AB5,
Right, the
is
pro
still
am.
being pushed at the state level in
Oh, sure.
various states, not just California. We just set the precedent for well, actually, other states set the I won't take credit for that. So what states are actually seeing this push? Like in what states do freelancers need to be aware that this is also possibly coming at the state level?
We are seeing, this started a lot of this started, at least from our understanding of it, because that's when we got involved after California passed the AB5, and that's when New Jersey got hit with the legislation. We have an ABC test here. They were trying to codify it into law. I guess there's a difference. So we still have it, but it's not law. Massachusetts has an ABC test. Theirs has been on the books for a long time, and they're, I think, my understanding is they're starting to enforce it more now, since they've gotten a lot more, I don't know, press about it. I don't know if that's, I know I've talked to a recruiter recently in Massachusetts, and he's saying there's a lot of independent contractors who will just sue the employers, and the employers won't make them employees, but then they get sued and they end up having to pay more in legal fees, all that. So Massachusetts is one to look at, but that one's not, they've got some Uber stuff going on, which we won't get into. Minnesota has the Minnesota Attorney General's Task Force on Worker Misclassification, which is yet another mouthful. And their goal is to protect employees and prevent them from being exploited by being improperly misclassified by independent contractors. So as part of this task force, they're looking at various ways that this may be happening. And they are also looking potentially at the ABC for potential use in the state. We are fortunate that one of our Fight for Freelancer members is on the task force representing freelancers. We're super grateful that she stepped up to do this volunteer work it's hard work, and she's on her own. So we've been supporting her in that, but she's doing a great job. New York has gone through several versions of looking at the ABC test. This came on the heels of what we were going through in New Jersey. So they had an ABC test being pushed, and then they had a task force during the pandemic. And then I think I don't remember all the details, but something happened. So it's being pushed again by the same senators. It's currently in the Labor Committee. I don't think it's moving yet. I think it's also might be in the Assembly as well in committee, but it hasn't, it's early. And so the purpose of their bill is to reclassify more workers as employees rather than independent contractors in order for them to receive benefits such as healthcare and retirement. And then Illinois has a Workforce Protection Act, and this is pre-ABC test, but it is my understanding that it's an opening for their state Senate to pass the ABC test. So it's kind of like one of the early steps. And I know California, Susan, feel free to correct me or add on, California has there's a legislator who I believe is introducing a bill to repeal AB5. Whether that will happen, who knows? But there's been talk. Kevin Kiley had done a press conference a few weeks back where this was announced. There was a state legislator who announced this was happening. So we will see what happens. So there is activity in basically it's the more liberal states that are pushing this. I think Washington State already has some legislation. They had some activity early on when we were doing the state work. So we opened up a group there, and then I think things calmed down. So, but those are kind of the bigger states to watch.
Yeah, even in California, even once they, repealed it for the 109 or whatever categories, the chilling effect already had happened and it didn't go away. So, just something to think about, that because companies are scared of being sued. And so that if they think there is legislation on the horizon, or the possibility that, it may, like, the state level is fine, but if it's going to come at the federal level, we don't want to touch it, and we're not going to, so just to be aware of that. I'm going to move to questions from people. One is for Wilson. What is the mysterious seventh factor in the DOL rule? Is it open-ended?
We'd
Yeah,
love
it's
to know
open.
that.
So the 6 factors I mentioned earlier, they're all sort of defined very broadly to begin with. But then the 7th factor is, I would call it a catch-all. It's just a statement that if there's anything that we forgot, it could also be relevant. What they're basically saying with this so-called 6-factor test is that any fact can be relevant to the determination of whether you're an independent contractor under the Fair Labor Standards Act. And we can't give you a comprehensive list of what's relevant because we might determine at some later date that there's something that we didn't think of in this rule that is relevant. So they had to make sure to include this catch-all factor. I think that's really not helpful for the regulated community. I think it introduces a whole lot of additional uncertainty because there are a lot of things that independent contractors do that don't fit cleanly within the factors, and it's not clear how the Department of Labor or a later trial lawyer might characterize them to be relevant. So yeah, it's simply a catch-all factor is what I was talking about when I mentioned the so-called 7 factors.
And somebody has said that they have the ear of their senator staffer and talked to her a couple of days ago, and she told this person that she understood the ruling was going back to a multi-factor economic reality test that was in place before 2021. This person would like to explain to her that that's not what's going to be the effect.
Well, it's definitely
and
not.
was wondering,
the Department of Labor could have simply issued a rule which withdrew the 2021 rule, and then that unequivocally would have restored the status quo ex ante, so the status quo prior to the 2021 rule being in place. That's not what the Department of Labor did, and it's obvious that's not what they did because there's a 339-page rule which explains the Department of Labor's new standard. And this new standard is very important because under the prior, in 2021, yes, the situation was not great, but you could look at the case law and get a measure of certainty and a measure of comfort. Here, the Department of Labor is announcing that there is no certainty, that anything could be relevant, and they do discard a lot of what the prior courts were doing. So, I think it's unequivocal that this rule is not simply a return. It is a return, or rather, it is a multi-factor balancing test, but so was the 2021 rule. But the difference is the 2021 rule provided businesses and freelancers with a measure of certainty, an ability to structure their relationship so that they could know whether or not they're independent contractors or not. That certainty is the main thing that the new rule is in the business of discarding. And they discard it not just from the 2021 rule, but from any certainty that you would have received from drawing on your circuit's case law or in the prior 2021 period. So again, I would just say if you wanted to make it simple, just say the Department of Labor could have withdrawn the 2021 rule. Could have been a simple withdrawal rule, but they deliberately chose not to do that. Instead, we have a 339-page rule with 6 factors, none of which are factors that were used by any court. They're factors that they purportedly draw on from cases, but imagine you had, sorry, I don't have to give this such a lengthy answer, but I just want to talk a little bit about this because this is important. The Department of Labor has 70 or 80 years of case law to draw on. So everything they do, they can say well, this is what this case did in 1985, and this is what this case did in 1979, this is what this case did in 1995. They always are able to cherry pick a case which has done what it is they want to. So they get to falsely, I think, argue that they're restoring some sort of status quo, but that status quo, that never existed. They've cherry picked the pieces that they want from this 70 years of history to put together the rule, which is the most unfriendly to freelancers they could possibly come up with. And because they're able to draw on 70 or 80 years of case law in doing that, you know, they have a lot of resources to draw on to come up with this very unfriendly rule. You know, the consequence of that, but yes, I agree. They're trying to make it seem like they are just going back to the way things used to be, but that's not the case. It's a amalgam of cherry-picked quotations to an 80-year mess of case law. There was a good reason the department put in place the 2021 rule, which clarified and solidified the standard and helped businesses and contractors know what the rules are, and that has been completely discarded without a good explanation in the new rule.
And somebody was wondering, probably an unanswerable question, what's the usual timeline for cases that challenge rules like this? Are we looking at months, years, decades?
I mean, it just depends. There's no clear answer. Sometimes it can be months. You know, if we win, I think, and the clearest example is the delay rule the Department of Labor put in place in 2021 to end the withdrawal. So their attempt to withdraw the 2021 rule, that was gotten rid of in months. I mean, I want to say that it was 5 or 6 months after the department attempted to withdraw the rule, the court struck that attempt down. So, you know, that's a distinct possibility, is that we get a quick victory and within a year, this rule is off the books. It's also possible that it takes longer. I mean, there's just no clear answer, but you know, if it does take longer, then we would be because we have to go all the way to an appellate court or even the Supreme Court on this issue. So, but we're hopeful that the district court can resolve this issue quickly, and if not us, one of the other cases will get the rule set aside.
Is there anything that freelancers can do to help support these cases, or is it just more they work their way through?
Well, I mean, look, I will say this. The Pacific Legal Foundation, myself, in this case, we're still looking for a plaintiff who works with a lot of independent contractors to bring a parallel case or potentially to join this lawsuit. So if you happen to know a business, I mean, we love our freelance clients, but the most clear application of this, as I've been saying from the beginning, is to a business who works with independent contractors. The problem is those businesses don't want to bring the Eye of Sauron down on them. They don't want to challenge this because it puts them in a situation where they feel like the Department of Labor is going to scrutinize their affairs. I don't think that's entirely fair, entirely accurate, but that's been sort of the reaction we've had. So we're still looking for a client that we could add to this lawsuit, or we could bring a separate lawsuit. So if you happen to have a connection with somebody like that, you know, please have them reach out to me, wfreeman@pacificlegal.org. So that's one thing that could happen. The other thing, you know, like Debbie said earlier, write your congressman, write your senator, just sort of raise the salience of this issue. The Department of Labor is unlikely to reverse course, but you know, this is just one front in the battle. I mean, we've talked about AB5, Debbie talked about all these other states. We talked about the PRO Act. I mean, this again is just federal wage and hour law, but there's so many other ways that people have to restrict your ability to work independently. And the effect of this rule is going to be gradual, but there are others which aren't so gradual. So I think the best thing you can do is stay engaged and advocate for yourself, and you know, keep it in the public eye that freelancers aren't being exploited, that freelancers are independent business people who just want to run their own business and have a right to do so.
And somebody said that was asking how well informed are our representatives on this act. They called theirs recently, and the staff sounded vague on their stance.
Debbie, you have an answer to, you might know more about the CRA process than I don't know the ins and outs of the CRA as it's going. I've been on some coalition calls where it's come up and people have talked about it going well. But honestly, like I worked on the Hill for a little while, and staffers being uninformed is not the most surprising thing I've ever heard. It is, they have a lot going on, and not all of it is policy related. And so, that could just be this, but that just goes to show you the importance of kind of elevating the salience of this issue and bringing it to people's attention, because there's, I think, a lot of deliberate confusion about the impact of this rule. I mean, the Department of Labor is falsely saying that they're just going back to a pre-existing standard, which, as I indicated, is not true. They are falsely saying it's for the protection of independent contractors, when in fact, the entire advocacy process behind it was from labor unions. So, I think that they've done what they can to kind of downplay the importance of this rule. And, it's up to us to kind of counteract that.
Yeah.
Yeah.
Oh, I would say I would agree. I think to say a legislator or aide knows a lot about a subject, it just depends on the legislator or aide. They all, they're dealing with so many different issues. And so some of the offices have aides who focus on specific areas, so they may know more. Some of the people you may call at the home office may not know more. And I don't know. I think it really depends on the people and what their specialty is and how long they've been doing this. And it also depends on their political bent or what. I mean, this should not be a political issue. Being able to work the way you want to work shouldn't be a political issue, but it is. So depending on kind of the viewpoint, and you probably would know what some of your legislators have voted for, and what types of things they enact. That you're going to come back with different questions or different views depending on that as well. What we really found to be the most helpful is telling your own story, because that's something that you can do as an individual writer, is to say, this is how I make a living. I am a freelancer because I'm home with my kids, because I have a disability, because I like the flexibility, because I need time off, I need to, whatever you need or want to be a freelancer for. I experienced harassment in the workplace before. I'm earning more money now as a freelancer than I did as an employee. I can't travel into work, so I need to work from home. And while that's better now after the pandemic, I still need to be able to call my own shots. And no freelancers, no employers do not provide the amount of flexibility you get as a freelancer. We get that a lot. They don't. So telling your own story and telling how the rule can affect you, or state legislation can affect you, that is going to be your best shot at getting through to them. The storytelling really makes a difference, and only you can tell your story. And so we've found that even some of the hardened aides will understand after that. And we've had legislators say to us before, oh, my spouse is a freelancer. Oh, I didn't realize this is how it could impact them. Like, the light goes off. We're small businesses. We're not, I mean, there are some people, we've always said there are some people who are misclassified, and they should get those benefits. But the vast majority of us are not misclassified, and we earn better living than you read about every time you see an article that has an Uber sticker in the corner of the picture. We earn a much better living. We're professionals, and they don't understand that. They're like, oh, you poor thing, you don't have minimum wage guarantees. I'm like, I make so much more than minimum wage. And then you say that, and then they're like, oh, they make faces at you because now you're bragging, and you're making the minimum wage people look bad, which is not the goal. So tell your story. That's my long-winded way of how to get through to your legislators and the aides.
Yeah, the best way to guarantee a minimum wage in freelancing is to say no to lower paying that don't pay what you want them to pay.
Yeah.
And I also think that as like these aides and stuff, if they're getting calls from a bunch of people and they didn't know what it was at first, they're going to be like, oh, wait a minute. Like there's a bunch of people calling about this. What is this thing that they're calling about? So the mass kind of helps with
Right.
that too. Somebody, Karen Anderson, you know her. She was wondering, how does the Department of Labor, how would the Department of Labor enforce the rule? Do they do audits, settlements, lawsuits?
All of that. Yeah, the Department of Labor does all of those things. They go after employers, or rather businesses, because here we're talking about independent contractors, but the Department of Labor, they're employers. And yeah, they'll of course do wage and hour audits. They will, and then they'll bring lawsuits. But that's not the only way that the Fair Labor Standards Act is enforced. It's also enforced, and I think Debbie mentioned this earlier, by plaintiffs' attorneys who can receive additional damages and punitive damages and attorney's fees potentially in a challenge to former employers' practices. So, that's another way that this can be enforced. But yeah, the main thing that's going to happen is going to be enforcement actions by the Department of Labor, and then lawsuits brought by former dissatisfied employees. So you're going to see, I mean, maybe you'll see, just gazing into the future, in 2025, you see a lawsuit brought by the Department of Labor against a magazine or newspaper for using freelance writers. And those writers should have been classified as employees, and they should have been paid overtime, and they weren't paid overtime. And the Department of Labor will apply this new rule, and they'll explain that under the totality of the circumstances, these should have been considered to be employees. And that successful lawsuit, applying that new rule, would be a potentially huge damages award against that company, and other companies will look at that and will change the way that they're doing business. And so that, I think, is the way this is going to happen in the future. Not just, but yeah, I mean, I think the real problem with the rule is because it's so vague, it gives the Department of Labor that hammer that they can bring down.
And somebody is asking how to get the story picked up by news media, but I really think it goes back to what Debbie was talking about these stories. It's about that freelancers aren't just like names, they're actual people.
Right.
I don't know if Debbie wants to pick up on that at all or not.
Yeah, I think especially for more local publications, telling your story. I am a freelancer. This is what I do. This is why I do it. I make a good living. I'm able to support my family. This is what the rule is, or this is what the state legislation is. This is what it does. This is how it's going to impact me. And then some statistics about freelancing in general and why we're not all the poor, mistreated people you think we are. We have a lot of stats on the Fight for Freelancers website. So I think it's fightforfreelancersusa.com. We have a lot of stats on there, and if you look at our the Facebook page as well, we've got a lot of stories that have been published, op-eds that have been published, and you can kind of go through and see how other people have written them, and then just reach out to the publications. We've done this quite a bit. We don't get in every time. So there's going to be a lot of, and then you got to find someplace else. So, especially if you know an editor who you think might be interested, maybe check in with them. Otherwise you got to shop it around.
And one thing I want to point out, if you are a freelancer and you're working 40 hours at a company and you're not getting benefits and you feel that you're being misclassified, there are misclassification laws already on the books that are enforceable.
Let me just interject on that point. The Department of Labor was clear that the 2021 rule gives them the power to go after concrete, the standard should be.
I think, was I the only one who lost him there? Okay, could you repeat that?
I was just saying, the 2021 rule gave the Department of Labor enough power to go after misclassification. It's not the case that if we win our lawsuit, that there's going to be a lot of misclassified workers who have no protection. It'll still be the case that the Department of Labor can bring enforcement actions. It's just a more concrete standard, tells people what the rules are so that they can make contracts and know what the consequences of those contracts are in advance.
Yeah, so these misclassification laws already exist. So if you are being misclassified, like contact somebody and let them know, because those can be rectified under current laws. So one last question. Don't want to make it political, but if there's a new administration in 2025, is it possible that the entire rule gets reversed, similar how the 21 rule got reversed with the new administration? Like, are we going to keep going back and forth depending on who wins what election in the
I
coming?
would rate that as a near certainty. Unfortunately, until the courts, until maybe even the Supreme Court kind of weighs in and helps, the Department of Labor sort of settle the standard, or until there's like a long period where one standard is in place and it proves to be workable, I think there is going to be a bit of a yo-yo here. And we've already seen that with the NLRA, where there's been a yo-yo on a number of different standards for who's an employee and who's not. And that's the federal labor law. So it's a different, one of those other laws that asks whether you're an employee or not. Labor unions law is what I meant to say. So yeah, this is going to be one of those yo-yoing issues, I think, for the near future, unless we get a court decision which clarifies, as we think. I mean, I think that there shouldn't be a yo-yo on this issue. I think a court should just come in and just say, what does the law mean? Who is an employee under the Fair Labor Standards Act is a question of law, should be decided by a court. So, but until a court does that, I think there's going to be a bit of a yo-yo, and the agency is just going to keep going back and forth.
And I guess let's wrap this up with any last thoughts on this. Parting thoughts.
No, I just want to say I appreciate that we've had a good crowd who have been engaged in this, and thank you for taking the time on a afternoon or evening to spend time learning about how this could affect you, what it is. It's not easy. It's not super exciting. It's not, an evening watching White Lotus on HBO. So, we appreciate that you're taking the time to do this and really do spread the word about what's happening and pay attention, because there's a lot of freelancers who just say, this isn't going to affect me. I don't know what you're talking about. You're being silly. They'll put you down for even bringing it up, and then it's hard to explain. So it's helpful. I'm glad that there were so many people here today who were paying attention. And I know we're going to have some on watching as well on replay. And thank you, Wilson.
Yeah, just to echo that, I mean, this was a great opportunity, and I really appreciate being invited and given an opportunity to speak about these difficult issues. I know this is a complicated area of law. If you're interested, I encourage you to read our complaint, which lays out some of the things I've said in a lot more detail. It's just really a matter of, raising the salience of this issue. We've said it all along, but I encourage people to advance their own independence, and just be clear, as Susan said earlier, you are independent business, you're small businesses, and you shouldn't be treated as though you're being exploited. You can take care of yourselves. And I think that's the theme that the Department of Labor needs to hear, even though they don't want to hear it.
And again, feel free to follow Fight for Freelancers on Facebook. ASJA has Facebook group for members, I believe. SPJ Freelances, the SPJ Freelance community, our Facebook group is actually open to everybody, even if you're not an SPJ member. So if you are a freelance journalist, you have to answer all 3 questions, though, or you are automatically declined. And then we also have Twitter feeds that we're pushing information out about this. Same for Fight for Freelancers. Twitter X, it's still twitter.com, so I still call it Twitter. And that is it. Thank you for joining us today.
Thank you, Susan, for
setting
Susan. This up and getting this all organized into SPJ, everybody on the back end who's helping to get this all done. We really, really appreciate it.
Yeah, and we will again, we're all volunteers, so we will post the video probably within the next few days, but give us some time, but we will post the video and send that around. And I will try to grab the links that were in the chat and maybe put that we put our videos on Facebook, so or on YouTube. So maybe I'll put the links, like see if we could put the links in the description under the YouTube in the YouTube description area. And that's it. Thank you
All
very
right.
much.
Thank you
Thank you
very
so
much.
much.
Have a good night.
Bye.
Bye.